All right, today we're jumping into a huge case from back in 2001, a case that really put one of our most personal rights, privacy, on trial. And it asks a question that's maybe even more important today than it was back then. We're talking about the case of Alika Khosla. So let's start with the big question, the one that's at the very heart of this whole thing. Think about it. Is your right to privacy absolute, like a total unbreakable shield? Or can it be challenged when the truth is on the line in a court of law? This is exactly what the Delhi High Court had to figure out. Now, before we get tangled up in all the legal jargon, it's super important to remember how this all started. This wasn't some abstract debate in a law school classroom. Nope. It began with a real story, a human story, a marriage that was falling apart. Okay, so let's meet our key players. We have Alika Khosla and her husband, Thomas Mathew. By 2001, they are locked in this really nasty divorce. And what are the grounds? Well, they're both pointing fingers, both accusing the other of adultery. It was shaping up to be a classic messy he said, she said situation. But then it took a turn nobody saw coming. And this is where things get, well, pretty wild. The husband, Thomas Mathew, makes this absolutely shocking claim. He alleges his wife had gotten pregnant by another man. Now, this pregnancy, it was a tubular one, had been terminated, but he claimed that the fetal tissue was still preserved at the All India Institute of Medical Sciences, AIMS, and he was convinced that a DNA test on that tissue would be the smoking gun to prove he wasn't the father. So right here you can see the legal collision course they were on. It's a total clash of rights. On one side, you have Alika Khosla who's saying, whoa, hold on, a DNA test on that tissue, that is a massive violation of my fundamental right to privacy under Article 21. But on the other side, Thomas Mathew is arguing, well, I have a right too, the right to present evidence and prove my case in court. So you've got these two fundamental rights staring each other down head to head. Okay, so this is where a very personal, very messy dispute turns into a major legal puzzle for the courts. They had to look past all the accusations and really zero in on the huge constitutional question at the heart of it all. And that question is this: can a court actually order a DNA test on preserved biological material against a person's will without stomping all over their constitutional right to privacy? I mean, really, does the court's hunt for the truth trump an individual's right to just be left alone? This was the knot that the judge had to untangle. So, what did the court do? Well, it wasn't a simple yes or no. That would have been too easy. Instead, the court did what courts often do. It performed a careful balancing act. Imagine a scale, with one person's rights on one side and the other's on the other. This whole approach is absolutely crucial to understanding how they landed on their final decision. Okay, to really get what the court decided, we have to look at the legal foundation they were standing on. They looked back at a really important earlier case, the Rajagopal case, and they started from there. They acknowledged that, yes, the right to privacy is fundamental. It's the right to be let alone. It's a core part of personal liberty. That was square one. But, and this is a huge but, there's a twist. The court immediately pivoted to other cases which had already established something incredibly important. This right to privacy, well, it's not absolute. It's not an unbreakable shield. It can, in fact, be limited when it bumps up against the rights of other people. And that was the crack on the door the court was looking for. So this all led to the court's final decision, which they broke down into 4 key points. Let's walk through them. Number 1, separation from the body. The court said, look, once the tissue was removed from her body and preserved in a hospital, it's kind of its own separate thing. Her privacy claim got weaker at that point. Number 2, the public record exception. Because this divorce was now a court case, it became a matter of public record, and that lowers the expectation of privacy. Number 3, the matrimonial context. In a divorce dispute, one person's right to privacy has to be balanced against the other person's right to actually prove their case. It's a two-way street. And finally, number 4, no compulsion. This was a really crucial distinction. They weren't forcing her to give a blood sample. The test was on material that was already sitting in a lab, totally separate from her. Okay, let's zoom out for a second and look at the big picture here. What does this all mean beyond just this one case? Well, this verdict really reinforced some major principles, setting a precedent for how Indian courts would handle this clash between privacy and the search for truth for years to come. So, what are the key takeaways from all this? Well, the biggest one is that privacy, even though it's a fundamental right, isn't untouchable. It's subject to what we call a balancing test. Basically, when your rights smash up against someone else's, a court has to step in and weigh them. Another big point, your right to privacy is strongest behind closed doors. Once your life becomes part of a public court record, that expectation of privacy shrinks. And this is especially true in matrimonial disputes, where one person's privacy might have to take a back seat to make sure the other person gets a fair shot at proving their case. So you might be sitting there thinking, okay, that's interesting, but this case is from 2001. That's ages ago. Why does it still matter? And the answer is because its legacy is huge. It's still shaping Indian law right now as we speak. And this timeline really shows you how. Back in 2001, you have the Alika Khosla case, which introduces this whole idea of the balancing test. Fast forward 16 years to 2017, and you get the massive landmark Puttaswamy judgment. This is the one that officially declares privacy a fundamental right. But, and you can probably guess what's coming, it also says that right is not absolute. Sound familiar? It's the same logic from the Khosla case. And even as recently as the Ivan Rathanam case, you see the Supreme Court still doing this exact same balancing act, saying you need an eminent need, a really, really good reason to order a DNA test. So, when you boil it all down, the core idea from this case from over 2 decades ago is still incredibly powerful. The idea that privacy isn't some impenetrable brick wall, but more like a flexible line in the sand that has to be balanced against other people's rights, that's not just some dusty old legal theory. It's a living, breathing principle that judges are using right now to decide cases on everything from paternity disputes to digital surveillance. And that really leaves us with one final big question to chew on. Back in 2001, the court was talking about preserved biological tissue, but today, we're all leaving behind a trail of digital tissue everywhere we go online. So in our world of social media, shared data, and endless digital footprints, where does your right to just be left alone truly begin and end?